Ladies and gentlemen, welcome aboard the Pilot Lawyer Podcast. Thank you for your attention while this important legal information is reviewed. What you hear should not replace consultation with an attorney and should not be considered advice for your situation. On behalf of the Pilot Lawyer and your entire crew, it's our pleasure to have you aboard.
Welcome, aviators, to the Pilot Lawyer Podcast with us, the Ison Brothers at the Ison Law Firm, where we discuss FAA medical certification for pilots and those who want to become pilots. For the next 30 minutes, just sit back and listen.
You know what? We'll fix it in post. Okay.
Yeah,
so what you're here for? We'll do it live.
Well, see what's happened is we've moved.
I'll write it, and we'll do it live.
Yeah, we've moved offices. We've lost our little scrap of paper that had the opening on it, and last week we did it by memory. Today I just can't get it quite right. So you're just gonna have to remember that this is the Ison Law Firm saying this is the Pilot Lawyer. And
insert intro. Laughing, crying, laughing with us or without us.
Great. Let's get into the substance.
Here's the thing, though. You know, really, for the cognitive dysfunction you just displayed, we should really be doing an episode on aeromedically significant cognitive deficits. But
the opportunity that we just missed makes me want to faint. So let's
pass
talk
out.
Let's
pass out.
Get the smelling salts.
Yes. So let's talk about it.
Well, let's talk about fainting.
If I fainted right now, could I get a medical certificate?
While you're in the presently unconscious state?
Sure, perhaps.
It'd probably be a better candidate unconscious than you would consciously.
I've got a question for you.
You can't weigh me that easily.
Or we can't talk about your fear of heights.
What do they call? What's that? Acrophobia. If you say vertigo, that's very telling of why I'm the least helpful.
Why'd you
I think it's
out?
acrophobia. Is it acrophobia?
I think why I associate.
Look it up, college.
Why I associate vertigo with fear of heights is because of the movie. Because of the movie.
Well, yeah, he's climbing up the ladder or whatever.
And
I think oh my God. Why'd you go up the ladder in the first place?
Didn't you know you were going to be afraid of heights?
It's like the people you see out there go on like a run on a day where it's clearly been raining. Now, all of a sudden it's raining and they're like, well, I didn't know it was going to rain, but it's been cloudy all day.
Well, you wouldn't have gone on a run.
I would have been. It was sunny or cloudy
otherwise.
I don't want to get a sunburn on sunny days. So if you
we have a lot of Jimmy Stewart and Alfred Hitchcock references on this podcast.
Well, you know, if you don't try, you don't get what you want. You want what you want.
So whatever.
It doesn't make any sense.
Did you
Nonsensical comments.
Yes, acrophobia is fear of heights.
Okay, good. Well, hey, so notwithstanding, let's say that's a good segue. Let's say you get up on a ladder and you have your acrophobia and you're just so afraid you pass out. Could you get a medical certificate in that case? Well, that brings us to the regulation because despite the angst and heartburn it gives some people when we say it, the FAA medical certification process is a legal process. So the fainting episode is tied to a regulation. So the relevant regulation for today's episode will be 14 CFR, Code of Federal Regulations, 67.109A2, 209A2, and 309A2.
And why are there three regulations?
Because it's for first class for 10, second class 20, third class 30, but they're copy and paste of one another.
I do what now?
They're copy and paste of one another. So because essentially the standards are largely the same for first, second, and third class.
Wait. If you're telling me largely the same, but they're not copy and paste.
There are very minute differences for a first class applicant with respect to some cardiac and some visual standards, but pretty much everything else is the same from first, second, and third class. So if you can get a third class for most things, you can get a first class. Second class doesn't make any difference. But back to the regulation at hand, 109A2, 209A2, 309A2, all say the same thing, which in essence, is sort of paraphrasing, essentially says, you can't have an established medical history or clinical diagnosis of a disturbance of consciousness without satisfactory medical explanation of the cause.
I have a question for the physician on the podcast. Yeah.
Let's hire one and see what they can say.
This is the point. This is the part of the podcast that Alex always puckers.
Yeah.
He never knows.
He never knows to say something.
He actually has to work for the paycheck.
Yeah.
What is an established medical history or clinical diagnosis? Boom, I said it.
What?
What? I couldn't be. Did I stutter?
Well, you didn't
Wouldn't put
complete
it
a
past
question.
Yeah, I did. What is an established medical history or clinical diagnosis?
Of fainting or something that's... I mean, you got to give me more detail here.
I'm going to present to you a question.
Okay. I'm ready to receive
In your
a complete
capacity as a licensed physician in the state of Florida,
Yes.
can you define for me the phrase established medical history or clinical diagnosis? Is there a difference between an established medical history or a clinical diagnosis?
No, they're the same thing. I would assume they're the same thing.
Not giving us the answers we want.
Listen, I'm not
An established
a doctor.
medical condition is, I had an issue. I went to the doctor. I've had multiple follow-ups on it. I've maybe had more than one episode of this issue.
So here, I think, is where the lawyer and the doctors are maybe going to be at war with one another. Is an established medical history requiring the individual to have sought treatment?
Yes.
But that's the thing. The FAA doesn't care if you've sought treatment for it. Question 18B on the medical application asks if you've ever had dizziness or fainting, right? So in theory, let's say you're out on the bayou gator hunting and you get the heat gets the best of you and you faint, right? But I come back to drive my airboat back to my shack and clean the gator up, act as though it's never happened.
You didn't get eaten by the gator while you were unconscious?
See, to me, like an established clinical
But let me finish the thought real fast before you jump in.
Oh, my God.
I've fainted. So do I have to report it? Well, yeah, the application's, eliciting whether or not I have fainted, 18 Bravo. So I still have to report it, and that's going to get the inquiry going, which, is, then the FAA is going to say, well, does he have this established medical history or clinical diagnosis? But it doesn't make any difference. No, they're still going to make the inquiry. Now,
I've had an epiphany while listening to both you and Alex here.
Oh, boy.
Now, sit down and follow me on this. The application, the 8500-8, at item 18B, Bravo, asks, have you ever in your life been diagnosed with, previously had, or presently have history of dizziness or unconsciousness, correct?
Correct. Yeah, unconsciousness for any reason.
Okay. The regulation, as we have butchered here and noted, at 67109A2, 209A2, and 309A2, asks,
Let me
states that you must have no established medical history or clinical diagnosis of disturbance of consciousness without satisfactory medical explanation of the cause. So here's the thing. Is it possible then that the application is going to encompass more items that wouldn't necessarily be regulatory disqualifying? Because it's asking about history of any kind of unconsciousness. Maybe you have that scenario where you pass out on the bayou and you come to and you go home and you never go see a doctor for it, right? Because it was just hot out or whatever and you slip, hit your head, knock yourself out or whatever, right? But you don't need to go see medical attention afterwards because you seem to you're doing fine.
Well,
so
I think
is there a disconnect is what I'm getting at here.
Yeah, you're blurring the lines a little because 18B says dizziness or fainting spell. 18C says unconsciousness for any reason. Now,
okay, so I
think
screwed
there's
that
a
up.
difference between I have a traumatic brain injury, I'm unconscious, I was knocked unconscious, versus I'm walking down the street and I faint, or I'm back to the bayou, or I'm climbing up the ladder and I faint. And that's where it comes to, well, why did you faint? Like if you had a TBI and you're hit in the head and you become unconscious, well, I know why you're unconscious. It's because you're smacked in the face or you're hit in the head. If you are put under anesthesia, people ask this a lot. I had surgery and I was put under anesthesia. I was unconscious for that. Well, sure, we know why. That's not fainting. So this regulation is asking, this is for situations where people have just sort of spontaneously fainted.
Okay, so
And
I messed up the question, but I still read 18B again.
18B says, quote, dizziness or fainting spell.
Okay. So a fainting spell.
Yeah, I had a spell.
What is the difference between a fainting spell and 18C, which is less?
I just said unconsciousness
is like due to like a TBI or something like that. Where a fainting spell is maybe...
Well, maybe the same. I've fainted. I'm unconscious.
That's my point.
Well, sure, but as far as the regulations,
you're looking at me like I'm some kind of.
But the regulation is not contemplating when you're unconsciousness for like a TBI. It's contemplating situations where you've fainted because of some unknown question, or if it was because you had a TBI, that satisfies the regulation because we know what caused it.
Is there some kind of metric we could go by here?
Let's look at. So the FAA outputs a syncope. Outputs a syncope disposition sheet. So what they're getting at here is simple or known cause, because that ties back to the regulation. If you have a known cause for why you fainted and it's completely resolved, and the AME, the aviation medical examiner, is able to satisfy the syncope decision tool, essentially you can be issued a medical certificate with no issue. So the syncope decision tool essentially inquires about 6 items. The AME is supposed to assess whether or not there is a sort of a known entity causing the fainting event. So, for example, the FAA suggests viral illness, GI, prolonged standing, dehydration, or blood draw. Probably the most common that we see are people who faint at the sight of blood. They get their blood draw and they faint. Some of these things like dehydration, viral illness, I don't see the FAA typically being thrilled with that as a reasonable medical explanation, unless there's some just unequivocal evidence that you were dehydrated. Maybe you were hospitalized for dehydration. You can prove that it was dehydration that caused the fainting. And then the second one is whether there's a typo on their decision tool. It says, were the individual incapacitated after the event?
Well, now I've seen it all. So I don't feel so bad about my
your
slip of the tongue earlier.
Yeah. So if you're incapacitated
the
after
federal
the
government
event,
can't get it right.
They can't get it right. The third one was, have there been any additional unrelated syncopal events within the past 5 years? Are there any elements of the history which cause you to question whether the event is of aeromedical concern? So that's giving the AME a lot of subjectivity and a lot of discretion. The fifth is, if evaluated by a medical professional, was the diagnosis cardiac or neurogenic, syncope, or any evidence of cardiac pathology or cause? And the sixth is, do you have any concerns regarding the individual or are unable to obtain a complete history? And so if the AME can say no to all these, they can issue the medical certificate, but that doesn't mean the FAA won't follow up to confirm to their satisfaction that there's a reasonable medical explanation for the cause.
How in the Blue Bayou is the AME going to be able to answer no to all this stuff if he doesn't know my medical history? Because he's just the AME I go to. He's not my treating provider. You got to walk in there with the medical evidence to support that the no's, if you can, all the no's to all 6. And even still, the AME may not be comfortable issuing it, even with looking at your medical history.
Can we take a brief time out here and kind of back up for a second?
Has your FAA medical certificate been denied? Are you concerned you may not be able to get a medical certificate from the FAA? Are you at risk for FAA action for failing to report your medical history appropriately? Call the pilot lawyer at 1-855-FAA-1215 to discuss your options for getting the FAA to issue your medical certificate and get you flying. We are happy to evaluate your case and discuss with you a plan for presenting your case to the AME or the FAA. Aviation law is all we do, nothing else.
I think the issue that we had earlier was due to a crisis of definition. And that definition between fainting and unconsciousness is the issue.
Do tell.
So typically fainting.
I saw him over there
well, then you got me
looking
fervently.
Fervently?
Yes,
fervently.
Feverishly. Or fervently.
Fervently.
Good God, who's the doctor and the attorney here? Okay.
I'm not sure about fervently.
Please feverishly look it up, okay? So, typically unconsciousness is due to a more major illness. So, like Anthony was saying, TBIs, maybe a brain tumor or something like that, and usually last longer than a fainting spell or syncope. So, fervently, yeah, that's what I said, fervently. You said fervishly.
Fervently.
Yeah.
Fervently.
Okay.
So, I think that kind of clears up the difference between B and C on the medical application.
Anthony, do you concur?
I concur.
You weren't paying attention?
I concur. So let's just keep moving. Let's keep moving. So then you get down to the situation where there is an unknown or unexplained cause. Why don't you walk us through that, Christopher? Why don't you give us that thought process?
All right. If you have an unknown or unexplained cause, or you've had multiple unrelated syncopal events, if it's been due to a cardiac cause such as myocardial infarction or ischemia, then you got to go see that page. Now, the evaluation data, though, that the AME would like you to have, or the FAA is going to want to see, is that you're going to have testing data that's been performed within the past 90 days. That will have to include a cardiac evaluation, an echocardiogram, an exercise stress test, a 14-day Holter event monitor, lab work to include hemoglobin A1C, lipid panel, and a complete blood count. You're going to need to have the EMS ambulance run sheet, if applicable to the situation, emergency department records, if applicable. And if you're age 40 or older at the time of the event, a carotid duplex ultrasound performed within the previous 1 year. Even if you have all that and it all looks good, unfortunately, the AME is going to have to defer your application to the FAA for possible special issuance authorization. Anthony, back to you.
Yeah, so get into the nitty-gritty of how would you prove to the FAA that somebody has had a reasonable explanation of cause. So sometimes we'll see situations where the FAA will deny somebody for this, that they're just not satisfied with reasonable explanation of cause. What are some things that we might recommend people consider when they're trying to establish for the FAA that there's a reasonable explanation for that cause?
Something that would give them a reasonable explanation for that cause?
Yeah.
I don't know.
So a cardiac workup, maybe a neurological evaluation.
Is it literally all the stuff that I just rambled off there?
Yeah, but let's say the FAA still says, hey, the cardiologist didn't come up with anything. What are you going to do then?
Well, then perhaps we send them to for an evaluation with a neurologist that specializes in aerospace.
You've already done that. And they said
I don't know. What are you looking for here?
I'm looking for you to say, what are we going to do?
What are we going to do?
I don't know. The neurologist said, yeah, you're fine. The cardiologist said, yeah, you're fine. Your primary care physician said, yeah, you're fine.
We take this sucker to trial.
Your dentist says you're fine.
Let's push it to trial. Yeah. Okay, listen, the qualified medical judgment here is saying you're good to go. If the FAA says, no, we don't think so, well, who's the qualified medical judgment? And at that point, you have a dispute has arisen where you have the Sharks and the Jets, right? And someone's going to have to adjudicate which one side's going to win.
I think that's
Are you
right.
with us, or are you typing out a little?
Yeah, I think that I'm trying to deal with a crisis at the same time. So just I'm trying to feed you enough information to keep the podcast going while I do my crisis aversion over here. You can't seem to pick up the cue on that. It's kind of frustrating. So just can you roll with it a little bit while I continue to peck this email?
All right, fine. Peck out the email. This is okay. If there is all this great data that you have generated throughout the evaluation process that basically says, listen, this individual is doing fine. There's really nothing here that, from the qualified medical perspective would give us concern as to this condition. You provide that to the FAA, they review it, they, look at it, they internalize it, and so on and so forth. And the next thing you know, here comes a denial letter. And why are they denying me? I have all this positive information supporting my eligibility that's now in my airman medical file, and yet I'm getting denied. If you're not able to work it out with the FAA such that they're going to give you an authorization for a special issuance for a first, second, or third class medical, or just an outright letter of eligibility to hold a medical, then your options essentially at that point are to request reconsideration and kind of escalate it up the chain of command to the extent that you eventually get what's called a final denial. Once you receive a final denial, even though you can still technically request reconsiderations of final denials and don't necessarily have to go to this next step that I'm about to talk about, with a final denial, that does then authorize you to petition the National Transportation Safety Board for review of the FAA's denial of your application due to this issue under 67-109, 209, 309A2 because of your history of fainting. And so essentially at that point, what you're trying to establish before an administrative law judge for the NTSB is that the FAA erroneously denied your application due to this history because the qualified medical judgment supports your eligibility. Now, the rub there is that when you go to the NTSB doesn't have any jurisdiction to tell the FAA to issue a special issuance. So essentially, when you go to the NTSB, you are making an argument that you are qualified for unrestricted medical certification. To a certain extent, because we're dealing in an area of the qualified medical judgment as opposed to something more strict like a specific disqualifying condition, you do have that kind of leeway to make the argument before the NTSB that, hey, listen, the FAA got it wrong here because look at all this positive, data from all these physicians, these qualified medical physicians that have evaluated me. They've run me up the flagpole. I say I'm good to go. And yet they denied me. So you do have that option as well. May not necessarily be an option for everybody in that situation. It really is fact specific, depends on their medical history, and to a certain extent, what data has been put into the airman medical file before that denial comes around. Because if you put bad data in, that's going to support the FAA's position, right? And even if you get good data subsequently, it could still hinder the process at the NTSB.
Well, I've got good news.
Did you avert the crisis?
My email crisis averted.
I can't wait to hear what that's about.
Turned out to be silly, in my opinion.
All right.
Resolved it. And not silly, but it wasn't as big a problem as I thought it was.
Well, listen, what you do in your personal time is your own personal issue.
Let me say this much.
When you're in these four walls here,
is that the type of case you'd want to take to the NTSB? Is that one you would like? Let's say you've got a neurologist and a cardiologist say, hey, this person's fine. They pass out from dehydration. The FAA said, no, we don't buy it. We don't like the medical explanation.
I would be more inclined to take a case like that to trial, or at least put it into the NTSB realm than per se a case where somebody has a specifically disqualifying condition, a condition that the regulation has written out, enumerated. You have this in your history, you're not getting a medical. That type of case doesn't belong before the NTSB because you're never going to be successful unless you can dispute the legitimacy of the diagnosis in the first place and that you ever had it, which is...
What are some things you could think you could do to stave off that they come into that? I think it's going to come down to the quality. Beg and plead. Sure. I think it's going to come down to the quality of the experts or the quality of the evaluators that you're putting into your airman medical file for the FAA to consider. If you're getting a letter from...
Credentials beyond reproach.
Yeah.
Indisputable.
Indisputable. If your doctor's doing a thorough evaluation as a well-trained, well-qualified cardiologist, on that's going to help. But you could go a step further sometimes, get someone who has aviation know-how, understanding of what the FAA is looking for, understanding of what is, a reasonable explanation for cause of the FAA. Somebody who has that approach, I think, is going to be helpful to get you through the process.
And if they don't have that, then maybe someone that's got board certification in that area definitely would be a plus. Somebody that actually does it on a daily basis. When I used to do medical malpractice, there would be experts that hadn't practiced medicine, but they would practice just enough to be able to meet the requirements to be an expert under, Florida law. But there were definitely varying degrees of those who practice. There were people that were on the stand getting paged because they were needed in surgery versus guys that, I did a surgery a year ago,
Mm-hmm.
So
that's absolutely right. So I guess the question here is, if you've fainted because you saw the sight of blood and that's no good for you.
Why do you keep coming back to that one?
Because that's the most common one we see, I think. You want to make sure you have your ducks in a row before you go and see your AME. Hopefully it won't be a problem.
Well, let me ask you this question. Let's say you can't establish a satisfactory explanation as to the fainting. Is there some kind of wait out period or sit down period?
That's a 2-year period. They want to see that, once it's 2 years.
Where does it say that, though?
It doesn't really say that. It does say that in the FAA's decision tools, but it's not in the regulation. One other thing I would say, if I may, what if you do come up with a satisfactory explanation for cause? What if it's because, I fainted, but it's because I got a bad ticker?
Well, now you got another issue.
Another problem.
Or was my raging substance dependence withdrawal that caused me to pass out?
Sure. I mean,
now you got a satisfactory. Yeah. Okay, we got past the fainting issue.
Yeah, now we've got a rabbit trail.
Pig trail?
Rabbit
I'm more familiar with the pig trail.
Wherever you go.
Where the bacon droppings are.
It's like pig droppings or bacon droppings. So it's one thing begets another.
Sure.
So
you got to be careful. I mean, sometimes people will, before they really put too much thought to it, they'll throw that out there, indiscriminately.
Yeah, well, it kind of goes back to this guy on the ladder. Sure, I fainted because of my acrophobia. And yeah, that makes sense. But now it's like, well, why? Two things. Does he have vertigo, like in the movie?
Oh,
or
wow.
now we got to look at that. Or does he have some sort of anxiety disorder that we need to run up the flagpole?
Well, I think that's kind of a good synopsis of the overall process and what you need to be concerned about, what you might need to. Oh, is there another one here?
No, we looked at all that.
The unexplained syncope after a cardiac evaluation that has been performed. I don't think we talked about that one.
Say it again.
Unexplained syncope after a cardiac evaluation has been performed and no cardiac cause found.
Yeah.
That requires deferral.
Yeah.
That requires you to get them all that stuff.
If it's a cardiac type thing causing an explanation, you're going to get deferred because that's something they have to run up the flagpole on the cardiac piece. But if it's something simple, as they call it in the decision tool, like a viral illness or stood for too long or the blood draw. Is it okay if I mention that again?
Hey, that's fine. It just seems like
that's where you'll be in a good shape. So.
All right. Well, this was a rather interesting half hour, I think. There were some laughs. There were some,
your version was interesting.
There were some laughs. There were some gaffes. There may have been some informative information.
I doubt it.
For my,
what's crazy?
For my part in it, I apologize.
You know what's offensive?
Please
tell.
Out.
Last episode, we talked about going on this walk across up to DC.
Yeah, we
tried to elicit people's interest. Nobody's contacted us. Number one.
Well, you turned the comments off.
I think they can call in, and I think and the thing about that is that they probably think we can't do it. Those poor boys.
Well, now that you posted that picture of us on the Facebook page sitting in here doing this, they actually say
understand.
There's no way.
There's no way.
In this heat.
Yeah.
With those
bodies,
with that BMI,
with that physique.
Yeah, I'm surprised they make it out to their car.
Yeah.
Anyhow,
which is the only way we'll commute to DC.
So we've talked about the issues. We've joked about the issues. We've
alienated listeners.
And now we're doing at the self-deprecating part.
I think we've done a pretty good job.
We're hitting all our marks.
Hitting everything. Yep.
So long story short, you may not think it, but we can help you if you need help. If you've had a history of fainting or loss of consciousness.
I think this issue really highlights the regulatory piece of it all. It comes down to under the regulation, they can sort of get away with certain things if they don't like it. And I think it also speaks to speaks to it being medical in nature, but that's all medical evidence that speaks to the regulation.
That's the thing. You got to have the medical evidence to support your eligibility as it's defined in the regulation.
Yeah.
Like if the regulation didn't require qualified medical judgment,
it's like
you may not even be going.
This medical piece is like, it's doctor to doctor or medical. Well, I've had 4 doctors that say I'm fine. So it's clearly not a medical issue. It's a regulatory issue that I'm trying to satisfy these regulatory requirements with medical evidence. don't get me going on that because people will be writing articles and really roasting us. And
we'll let them because they're going to be wrong.
They're wrong. You're wrong. So that's all we have to say.
All right. Well,
okay.
So you've logged an uneventful half hour listening to the Pilot Lawyer podcast with us, the Ison Brothers. We've lost our witty little outro. We don't really have anything funny to say anymore.
The scrap of paper that it was written on.
Never anything funny to say.
Yep. So anyhow, we'll see what the next episode is going to be about. It'll probably be about
something interesting.
Something interesting, maybe more so than this. But I'm sure I will promise you this.
He's pointing in the air.
I will definitely have more gaffes.
We should set up an email address so that people can send us topics they're interested in.
Podcast at the Ison.
Podcast at the Ison Lawyer.
Yeah.
At the Pilot Lawyer.
And we won't receive anything.
Yeah. That would be the sad thing.
That's
how the podcast
We don't want to hear any
ends.
more of this.
Yeah.
All right.
Okay. Take care.
This is thepodcastfactory.com.